Welcome. Thank you for joining me this morning. I just mentioned it, but we are going to be covering quite a bit of information. So if as I'm going, you have questions, feel free to put those in the chat or the Q&A section. And if we don't have a chance to answer it today, you can of course set up an appointment with myself or one of our other attorneys for after the webinar. So I am Victoria. I'm one of the estate planning attorneys with the Koppenberger Law Firm. I primarily actually service our Northern California offices, but I am currently sitting in our Orange County office. So if you want to meet with me and you're not in Northern California, the good news is between Zoom and just being down here fairly frequently, I could do face-to-face or we could do virtual. We're essentially today going through a crash course, not only in estate planning for new adults, but also a crash course in what happens if my child is now that young adult. What do I need to think about? How do I now protect them now that they are legally an adult? What does my estate plan need to look like? And ultimately, what does your legacy look like and what do you want it to look like? So we're going to go through all of this today. And again, if I don't have a chance to answer your questions, we can of course talk about that in a consultation. But if you do have one, please don't hesitate to put it in the chat or the Q&A section. So the first topic that we're going to talk about is Estate Planning 101. So if you are sitting here and you are a young adult and you don't know what estate planning is, or you've heard your parents talk about it, but you don't really know what it entails, this is going to be a great crash course for you. Now, if you do have an estate plan, this is also a really good refresher to remind you of why those documents you have are so important, but also why keeping them up to date can be so vitally important. So we're going to go through the basics of estate planning. So what that means is we're going to cover the documents that generally speaking are in your estate plan and the documents that anybody over the age of 18 just has to have. The first one that we're going to cover is your Advanced Healthcare Directive. This one, I argue, is the most important document that someone over the age of 18 should have, but also needs to have kept up to date. In 2004, HIPAA laws changed to essentially say that nobody, not even your spouse, not your parents, not your child, has an automatic right to make any medical decisions on your behalf. So if you are not able to verbally tell the doctor who you would want to have that authority, you have to have it in writing. Otherwise, nobody has that authority. So this can unfortunately leave you incredibly vulnerable if you were rushed to the hospital after a car accident. You can't talk to the doctor because you're, let's say, unconscious or you're even in a coma. And if the person who's coming to the hospital that's your loved one to advocate for you doesn't have in writing that they are able to, the doctors legally can't even tell them what room you are in. We have unfortunately seen this situation play out. It is incredibly heartbreaking because the reality is this is such an easy document to set up that gives you an incredible amount of protection. And so for those who don't have one, it really is heartbreaking to see that they are now being left vulnerable. So if you are over the age of 18 and don't have a healthcare directive, now is absolutely the time to set one up. I know it's so easy when you're young to think, well, what are the odds of that actually happening? Do I really need to get one done? And in most instances, you don't have a catastrophe. The good news is that is not the common scenario that we see. The problem is we don't know what's going to happen. And so that is not something that you want to gamble with. This is a document that goes into action immediately. So again, if all of a sudden the worst happened and tomorrow you were in an accident and you couldn't advocate for yourself, the person you've named just has to bring that in and they can then advocate on your behalf. So again, if you don't have one, now is the time to get one set up. If you haven't had yours reviewed in the last 5 years, I would also strongly recommend coming in to ensure it still captures your wishes today. The next document that we're going to cover is your durable power of attorney. Now, this one is dealing with the financial aspect. Where the healthcare directive deals with healthcare, your durable power of attorney is ensuring that if you became incapacitated, your financial means don't just have to sit there idle while you are in need of that care and of those finances. So essentially what happens is you set up a power of attorney. Again, if you're over 18, this is such an important document to have, because if you did become incapacitated, this is who then would have the authority to manage your finances and pay for any care that you now need. Again, that sort of thing has to be in writing. Even if you verbally have told the person, you're who I would want, the banks and other institutions aren't going to take their word for it. It has to be in writing. So similar to the healthcare directive, now is the time to get that done. Again, we hope you don't need to use this ever, or at least not for many, many years, but we never know what could happen, and you don't want you or your finances to be vulnerable or unusable. One of the biggest issues with not having those documents is if you did become incapacitated, there is then a need for what's called a conservatorship. So again, if you've put in writing who would take care of you or who would take care of the finances, you've already dictated that, which means the court does not have to get involved. But if you either don't have these documents in place or they're out of date and so may not be currently protecting you, you then would have to go to court, or your loved ones would have to go to court to petition to take care of you and to take care of the estate. The conservator who ultimately gets appointed would oversee finances and manage your physical care, your living arrangements, basically do everything that those other documents could have provided for anyways. So again, you essentially have a choice when it comes to incapacity. You can either pre-plan and ensure that your wishes are predetermined and laid out, or unfortunately, you can go to court and have them determine who would take care of you and the finances. One of the other issues with going to court is they may not appoint the person you would want. One of my best friends, when she got married, I asked her, do you need to update your healthcare directive now to name your spouse? And she said no. And the reason for that was, as much as she loves him, he does not do well in hospitals. He sees blood and he's more likely to pass out than be able to advocate for her. So that is then not someone you would probably want as your primary person. The problem is if she had had to go to court or her loved ones had had to go to court, the odds are the court would have named her spouse then as the person to take care of her. Now, he could do the job. That is a very mild example, but you can understand that if the court is actually determining the who, you don't then get a say, and it may not be the appropriate person to take care of you. So again, if you don't have those two documents, it is absolutely the time to get them set up. And if you haven't seen us in the last 5 years, please come in for a review so that we can ensure you really are still protected. Now we've talked about two of the foundational documents if you're over 18, but let's now start talking about a little bit more of advanced estate planning. So a will is there to ensure that your wishes are carried out. However, you only qualify for a will, or I should say are only fully protected with a will if you do not have real estate or if you have less than $166,250. These are very important benchmarks that I will talk about in just a minute. If you are the parent of a minor child, you need a will regardless of those other two components. So if you have minor kids and you do not have any type of will set up, your children then are being left vulnerable if something happened to you, because the will is where you name who would actually take care of them if something happened to you or your spouse if you have a spouse. Now, for many, many young adults, a will is a perfect starting place because for so many of us, we don't own real estate or we don't have an estate that crosses that $166,000 line. So this really is a great foundational place for so many to start. However, it is really important to note that as your life continues to change and evolve, your estate plan must as well. Because the issue is if you do get real estate or your estate grows to greater than that dollar figure, you could then be subject to what's called probate. So probate is yet another court process. It's there so that the accounts are settled with the living and that on that behalf of the decedent. And ultimately, it is transferring title from the decedent to what are called their heirs or beneficiaries. So the issue, if you didn't pick up on it with the conservatorship conversation, is again, court is not somewhere that we want to see people end up because A, it's incredibly time consuming. B, it is incredibly cost ineffective. But C, your wishes may not be the ones that would be carried out. The court has to follow certain guidelines and rules. And so if those guidelines and rules do not comply with what you would have wanted, unfortunately, the rules are going to be the ones carried out. One of the biggest issues, though, with probate is the fact that it is time consuming and cost consuming. A lot of times people don't fully understand how expensive probate is until, unfortunately, they or a loved one are going through it. But if you talk to anybody who has experienced the probate court, or frankly, just court in general, they can probably pretty strongly attest to the fact it was not expedient and it cost a lot of money. Because probate is a legal process that follows the state rules, again, the person who passed away's wishes may not be the ones that are actually carried out. Because, like I said, the court has to follow their rules. I already mentioned that it can cause lengthy delay in settling the estate. On average, we see probate lasting anywhere from 2 to 4 years, which can seem kind of astronomical given how often the administration didn't have to take that long. Again, the control is with the court and not the family. One of the other issues is it is now a public proceeding. I don't know about you, but if I have kept something private during my lifetime, like my financial means or my family information, I do not want that becoming public even after I've passed away. But the issue is if you go through court, it becomes part of public record. And then I mentioned that cost. So probate costs about 5 to 7% of the gross estate. Now, again, these are fees set by the court. So this is not even the attorney dictating it. It really is the court dictating it. I had a client the other day who was questioning, why did I need an estate plan to protect me from probate? Is it really that costly? And I did a very quick calculation on just the $1.8 million house, so not factoring in any of the rest of their assets. And with the cost of probate, they could have been paying up to $64,000 to have just that house distributed to his children exactly as he would have wanted it anyways. So again, this is something that we really do want to avoid if possible. So if a will does not actually fit what you need and it is not going to provide adequate protection, the good news is we can then establish what is called a living trust. The huge advantage to a living trust is that it does allow you to avoid probate. Now, there's more to it than just that. And so if you have questions on making sure your trust is really adequately protecting you from probate, please come and talk to us because there's a lot of discussion that goes into protecting your assets. But essentially, a living trust is a contract between what is called the settlor and the trustee. As the settlor, you are setting the contract terms. So if you come in to establish a trust, you are then considered the settlor because you are creating it. And then the trustee is who actually carries out the settlor's wishes. In almost all instances, the settlor and trustee are going to be the same person initially. But it is important to note the trustee is a position that eventually will have to change if you become incapacitated or pass away. The only downside to a trust is that it only protects what it owns. And so I just mentioned if you are concerned or want clarification on, is my trust protecting me from probate, it's important to come and talk to us. Because one of the things that we talk to our clients in our signing appointments about is that you've taken a wonderful step to sign this trust and get it into effect, but you still have some homework to do after that appointment. Assets have to actually be transferred into the name of the trust. And this can be confusing. And often if you forget to do it after the appointment, it doesn't get done for many, many years. So if you are, again, wondering how to do it, did I do it? How do I verify that it's done? Please come and talk to us because this is such an important part of establishing your trust. Now, I already covered a little bit about who the settlor is, but essentially settlor is a fancy way of saying the creator of the trust. Whoever creates the trust is always going to be known as the settlor. This is not a position that changes from person to person. It'll stay consistent. Again, the trustee is a variable though, because you will be likely the trustee when you set it up, but at some point you will either become incapacitated or pass away. And so then you will have named what are called successor trustees. And these are the people in charge of managing and investing the trust assets, but more importantly, following the terms that you have already laid out. So again, this ensures that the control is in your hands rather than in someone else's, whether that be the court, whether that be a family member, a friend, or some independent party. Your trust is yours. And so those terms you established are the ones that have to be carried out. I've had clients ask me, well, what if a trustee doesn't agree with what I've put? Frankly, it doesn't matter if they agree or disagree. If they believe they couldn't carry out your wishes, then they shouldn't be serving in that capacity. Otherwise, they have to follow what you have put in writing. And then last but not least, who are your beneficiaries going to be? These are the persons or entities that you actually name in your trust that will get the financial benefit from your assets. And so there can be actually quite a bit of discussion when it comes to beneficiaries. This can wrap around, do you have minor children? Do you now have adult children, which we're going to be talking a lot about today? Do you have special needs children? Do you want to leave things to charity or a church or other institutions? There's a lot that goes into the beneficiary discussion because often it is more complicated than just, I want it divided equally amongst my kids, because every family is going to be a little bit different and not every child is going to be able to inherit the same way as their siblings may be able to. Now, one of the, again, biggest benefits of a living trust is it avoids that cost and delay of probate. So I mentioned to that client that I met with that had the $1.8 million house, and they could have paid up to $64,000 if that house had to go through probate. Well, your trust avoids that. We transfer the title of your house into the trust so that it doesn't have to go through court and it doesn't have to incur that astronomical expense. It also protects your privacy. So a trust does not have to be filed with anybody. It can stay as private as you want it to be. Nobody has to be given your trust while you are alive. So if you are an incredibly private person, that's absolutely fine, and your trust will allow you to be that way. If you're comfortable with just your children seeing it, you can determine that. Long story short is you have the control of who can actually see your document. One of the other big benefits is that it allows for advanced tax planning. So for those of you who already have an estate plan, when you first set up your estate plan, your estate may have been significantly smaller than it is today. And so as your estate grows, we need to ensure that you are not going to be paying unnecessary taxes. And so there is a lot that we can do with planning to either greatly reduce or completely eliminate the need for any sort of tax. So if you have questions about that, please come and talk to us. Now, some of the biggest components that are protected with a living trust is that it avoids what are called court supervised guardianships, or as we already talked about, conservatorships. With the conservatorship, again, the trust is looking to protect you and make sure that you do not have to go to court to have people named to take care of you. But there's also the issue of what if I have a minor child or children and something happens to me? Again, if you have not put in writing who's actually going to take guardianship of your child, the court is going to have to do that. And so the huge advantage to your trust is that not only are you protected from court, but your kids are protected from court. And so again, if you have not had your guardianship looked at or updated, we should probably take a look at it now. Or if you've never established guardianship provisions for your kids, please do not delay. Again, while we never want the worst to happen, and we in most cases do not see it occur, the most heartbreaking situations are where not only you have now become vulnerable to something, but now your children are as well. So the trust is able to protect all parties involved. And then, of course, ultimately, it ensures that your wishes and not the court's are the ones carried out. Now, I mentioned wills earlier, and I was talking about what are called standalone wills. Those are wills that you establish before you have a trust. But once you establish a trust, you will still have a type of will. That is called a pour-over will. Essentially, what it does is it accompanies the trust and is there to be a safety net for assets. I mentioned that there are assets that need to actually be transferred into the name of the trust. And what can happen though is, again, you leave that signing appointment, you forget to transfer a checking account into the trust, you now pass away, and that asset in theory would be left subject to probate. But here comes your pour over will, and it is designed to scoop that asset up and tells the court to give it back to your trust so that rather than the court dictating where it will go, it ultimately will go with the rest of your estate. However, that will, while it allows your wishes to be the ones ultimately carried out, does not actually avoid the full probate process. So again, it is still vitally important to ensure your assets are properly titled to protect you from any sort of court experience. But then one of the biggest components, again, with your will is naming guardians for minor children. So whether you have the standalone will or a pour-over will, either one is where we would name the actual guardians who would care for your children if you no longer could. So truly, if your kids are being left unprotected right now, please come and talk to us so that we can ensure that does not continue. All right. So essentially, when is the right time to begin your planning? The answer is if you are 18 and have not started your planning, today is the right time to start your planning. Because once you hit 18, your parents no longer have any automatic right, like I mentioned, to make any medical decisions or manage any financial needs that you may have. So those are going to be huge things to ensure your child has put in place, or if you are sitting here and don't have them in place, that you come and talk to us. A lot of times our clients are the parents, and they will essentially gift their children the healthcare directive and durable power of attorney. And so it can allow your kids to have these plans put in place without potentially having them need to pay the financial component. Because depending on if they've had a job or what their means are, they may not be able to afford these documents. So this can be a fantastic gift for parents to give their children to ensure that just because you're 18 doesn't mean you will be left unprotected. And then, of course, if you are at the point that you have minor children, we do need to set up those wills. And if a will is not going to adequately protect you or your estate, then we're also going to be looking at setting up a trust for you. All right, so that was a lot of, again, it's a crash course for people who don't have an estate plan or need a refresher on what their estate plan entails. But now we're going to shift over to talking more to the parents and grandparents of a new adult. One of the biggest changes is that you no longer need guardianship provisions. So once your child reaches 18 years old, you don't need to have then guardians named because they're considered a legal adult, as scary as that may be for some. So that is one of the biggest changes that does occur at that point. But we also then are looking at who are they as an adult? Are they able to manage an inheritance if something happened to you? Are they going to be able to protect themselves? And one of the biggest then components of this is dealing with, do you have a special needs child? Is your child going to be able at any point to be self-sufficient now that they are an adult? And do they have to be on any kind of government benefits? One of the issues with an inheritance is if it just pays to a special needs child, that can then make them actually lose government benefits that they desperately need. And programs may even seek reimbursement, and they may not requalify until that inheritance is completely depleted. The good news, though, is you can still give your child an inheritance without any of these consequences. The way to do that is by setting up a special needs trust. And so the great thing here is you don't have to decide to leave your child an inheritance or not, because so many families will come in and say, I really don't want to exclude them, but they're on a government program and I don't want them disqualified from it. And so we're able to then talk to them and say, you actually have quite a few options so that your child can still inherit from you. So if you do have a special needs child, or you know someone that does, please don't be disheartened. There is so much planning that we can still do to protect that child throughout their adulthood and even after you are gone. Within your special needs trust, we're looking to really build a team of advocates for that special needs child. Now, for some people, the special need is not going to kick in until they are significantly older, but we can still do that pre-planning so that depending on what the condition is, if it all of a sudden progresses rapidly, they already have protection in place. I talked to a client recently who doesn't know if their child is going to actually need special needs planning in the future. It's incredibly likely that she will, but it's one of those unfortunate diseases that they don't have a clear understanding of when it would actually debilitate her or if it ever actually would. So setting up this planning ahead of time essentially just ensures that regardless of if our client is still alive or if her child still needs care, the child is provided for no matter what. So that team of advocates that you're building not only allows for you to have peace of mind, but it ensures that your child is never left vulnerable if something were to happen. That financial planning also is going to take into consideration inflation, taxes, life insurance. So we go through a very customized plan that's going to look at what are your financial means and what are the consequences or benefits of those means. And then we're looking at, are they still going to need care as an elderly adult? So again, every type of special need is slightly different. And so we want to ensure that no matter what your situation is, your estate plan is customized to fit your need. Now, what about other children? So just because a child turns 18 does not automatically mean that they mature overnight. Many of us don't mature until significantly later. And so one of the concerns is if something happened to you when they were 18 or 21, 25, could they actually handle receiving their inheritance? And there are unfortunately some scary statistics that inheritance is given to children less than 25, generally speaking, get depleted significantly faster than those who receive it after 25. Now, that doesn't mean that the benefit of your estate could not be used for your child before they reach 25. In so many cases, we have a trustee named that is designed to manage the child's inheritance until they hit that benchmark. So that when they do, they're given the actual reins to control it themselves. But prior to that, they still have a safety net of someone who has the responsibility and sense to manage it properly rather than risking it being depleted rapidly. One of the ways that we can also protect your child is by setting up what is called a protective lifetime trust or generation skipping trust. Essentially, what this does is it insulates your child's inheritance for their lifetime. So no matter what age they are when you pass away, their inheritance is going to be protected from creditors, lawsuits, bankruptcy, the IRS, and a divorcing spouse. The last one is often the one that is the most concerning for parents, where maybe their child has already gone through a divorce and they're concerned about future spouses. Or maybe the current spouse, they're not sure is actually going to be a forever spouse. Whatever the situation may be, that protective trust that we can establish will protect your child's inheritance from being taken away from them. And then you can also decide, can they manage that inheritance themselves? Can they manage it as a co-trustee with someone else? Or should they not have any control over their inheritance regardless of age? Essentially, what I'm saying is whatever your individualized situation looks like, and that can be child by child, we can do a customized estate plan to protect each member of your family. Now, I mentioned this on the previous slide, but again, if you do set up these protective trusts, your child can still manage their own inheritance. It does not preclude them from being the one in charge of it. And they can, of course, still benefit from it. One of the biggest advantages is that the trust also will pass tax-free to your grandchildren, which can be a huge benefit to your grandkids. But it also then is ensuring that from a legacy standpoint, you are protecting multiple generations within your estate plan. So if you have any questions about this type of protective planning, or how do you set it up? Do I already have it? Whatever the question may be, please come and talk to us. All right, so one of the things I also mentioned is that they don't have to be the person who's actually in charge of their protective trust. In some situations, people come to us and they say, well, my child is unfortunately an addict, or they cannot manage money to save their life. I have a relative where if you hand him $1, he'll turn around and spend 5. And so he is then someone who probably is not the best person to be in charge of his inheritance, at least not solely, because unfortunately, he just can't save money and he spends. That doesn't make him a bad person. It doesn't mean he shouldn't receive an inheritance from his parents. It just means he needs more protection, essentially from himself. But you ultimately get to decide what they can use it for. So you can be as open with what they are able to use it for, or as selective as what you would want them to use it for. In some circumstances, we have parents who say, I just want this to go either to their education or to my grandchildren's education. And that is fine. Again, these are customized estate plans where you are in control and it is dictated by your terms. All right, so now what happens again, your child becomes 18. They're now actually 25 when you come and talk to us, but they're a legal adult. And now we start talking about, should your child now take on the responsibilities that someone else had been appointed to do when they were still minors? So now we're going to be talking about actually naming your new adult in these important roles. So that could be managing the finances. This could be managing your medical care and advocating on your behalf. It could be all of the above. But whatever that looks like, we want to discuss with you, is your child the best person to be in that role at this point? Should they still not be in that role? Do they need a co with them? Whatever, again, it looks like, we're able to do what your wishes need to be. So is your new adult ready to be named as your successor trustee? I mentioned at the beginning that while you may be the initial trustee, we name successor trustees within your document so that when you no longer can manage the finances, someone is already named to take over so that the court doesn't have to do so. Well, prior to your child being 18, there would have had to be someone who's a legal adult named in that capacity. But now that your child is the legal adult, you may be wanting them to be the person who would manage your finances if you no longer could. And the same goes for your healthcare directive and durable power of attorney. Again, when your child was not 18 years old, you likely then had other people named in that position or positions. But now that they've reached 18, we can talk to you about, are they going to be able to adequately manage money? Are they emotionally going to be able to make medical decisions on your behalf? And in some cases, the answer is absolutely yes. But in others, it's, well, no, maybe we should still wait a little bit because they aren't quite there. They're still figuring themselves out. They're getting their feet under them. They're starting their own careers. And so you're concerned about time. It's not going to be a one size fits all. It doesn't mean that my child's 18, which means they automatically have to go into these roles. It really is going to be looked at on a case by case basis. One of the other roles that I have not talked about yet is what is called the competency determiner. This is a vitally important role that goes into your trust. Essentially, this is the person or people that are going to actually determine, are you still capable of managing your own finances? Now, this seems like such a small thing, but again, by naming people, you are avoiding the court having to determine that. Because if you don't have people named or some sort of plan of who would actually determine your competency, the court is going to have to be the one that does that. So this is, again, something that if you don't have in your trust and you had it established with a different law firm, please have us review it to ensure that role is provided for. If you are one of our current clients, this is then something we want to review on an average of every 3 to 5 years to ensure that the people you have named are still the people you would want in that role. Now, I already mentioned this, but a successor trustee is ultimately responsible for making sure the trust assets are distributed according to your wishes. Now, being a successor trustee or the current acting trustee is an actual job. And so this is where it's important when we're discussing who would be in this role, that you're really considering who has good business sense, who is able to manage money well, who is organized, because there can be a lot of bills and paperwork that comes up, but it is an actual job. And so in some families, the child is never going to be the person named in this role because they just don't have the ability to serve. And that is completely okay. We also have parents who are concerned that, well, is my youngest going to be upset that they weren't the one named as the trustee, or is there going to be conflict? And I say pretty much in all circumstances, the ones not named as the trustee are actually going to be a bit happier because they don't have the responsibility of carrying out the trust and carrying out your wishes. But again, this is something that is very case by case. And so please come and talk to us if you haven't had your successor trustees reviewed since your children became adults, or if you haven't had it reviewed in the last 3 to 5 years. Now, I mentioned that as a trustee, it is a job. And so when someone becomes incapacitated, you as the trustee then become responsible for ensuring their bills are still paid, that their care is provided for, that if they have to move to an assisted care facility, that that's all set up. So while someone's alive but incapacitated, you're really managing their day-to-day life. But what happens if they pass away? Well, now you still have a job to do, but it's actually an even bigger job and generally requires more paperwork. So at that point, land records have to be updated. The county assessor needs to be notified. Any other beneficiaries named in that trust have to be notified. The Department of Healthcare Services has to be notified. You have to actually lodge the will and testament with the court. Now, this is, again, a very private document, so don't be concerned that the court would have any information that was private, but you have to tell them that somebody's passed away. Once someone passes away, their social security number stops, which means the trust, as it's finishing up, needs its own taxpayer identification number. And then we also need to update the IRS and say that for that final personal income tax return, the new person is going to be the one filing it, because again, we have to tell them that someone has passed away. Now, this is actually a very condensed list of what has to be done. And every single trust and situation will have to be done a little bit differently than any other. But this is just a quick look at, as a trustee, you do have a job to do when someone passes away. Now, one of the biggest advantages to the Koppenbarger Law Firm is we have an administration department that is staffed with currently 2 full-time attorneys and multiple paralegals. And so we are here to assist you and to ensure that you don't miss any steps, that if you have questions, you have a safe place and a person who can represent and advocate for you. And we can actually do quite a bit of this work so that that burden doesn't just fall squarely on your shoulders. So if you are in the trustee position and you have questions of what did I actually sign up for, or you're currently having to do things because someone's passed away, please come and talk to us. I had to serve as the trustee when my grandma passed away. And even though I do this job every single day, serving as a trustee can still be an incredibly overwhelming role to play, because not only do you have, again, a job, you're also grieving the fact that somebody's passed. And so I ended up hiring our firm to represent me with all of these tasks because I wanted to be able to just focus on the grieving component and not having to look at all of the minutiae details. So truly, I would absolutely recommend, if you are named as a trustee or are having to currently serve as someone else's trustee, Please come and talk to us if you have any questions. Now, with a job comes responsibilities. And so I'm not going to go through all of these, but it again is important to know that as a trustee, you have actual duties that need to be carried out. Now, in families where there's one child, everything's going to them, they're the trustee, there's no other players involved, we're really not going to be concerned about every single one of these being followed to the letter. Or if you have a family that is incredibly cohesive and everybody's very transparent with each other, again, we're not as concerned. But if you have a family like mine, where there is unfortunately going to be conflict when loved ones pass away, then whoever is serving as trustee really needs to ensure that these are followed to the letter. And so again, if you are the person named in that capacity or serving currently in that capacity, I would recommend having counsel, whether it is us or somebody else, to ensure that if you are in one of those tumultuous families, you don't accidentally make yourself liable for something that you didn't even know you were doing. So do come and talk to us if you have questions. Now, one of the biggest things that comes with working with the Koppenberger Law Firm is that we truly believe every single client's legacy matters. Our founding partner, Lloyd Koppenberger, started the firm because he did not like seeing people who were told they were too poor being turned away because their estate plan just wasn't worth it to attorneys. He absolutely started this firm with the vision and has carried it out that any person that walks through this door has a legacy to leave. That doesn't just mean a financial legacy. It can also be an emotional legacy. It could be the morals and values that you want to leave to your family. We can actually create what is called a family constitution, where family members agree to carrying out different morals and values and things that really matter to you. Your legacy may be the memories that you have created or that you have carried from your prior generations. One of my favorite legacies that I have received from my grandmother is her recipes. So many of these recipes were not only modified and created by her, but they were also created by my great-grandmother. And so that is one of the most important and powerful legacies that my grandmother could have left, because every time I make one of those recipes, I think about her, or I think about her when she made them for me for different events or holidays. And so again, we believe here that regardless of your financial means, your legacy encompasses so much more. So your estate plan can directly contribute to leaving that legacy. It makes sure that you are taken care of, because you are so important, not only to us, but to your loved ones, to your community, to your animals, whoever it is in your life that loves you. They want to ensure you are taken care of. If you are married, it also ensures your significant other is taken care of, so that when you do pass, they're not left vulnerable either. And then, of course, if you have children, you can leave those lasting protections, not only for your children, but for your future generations. And so even after you are long gone, your future generations can still benefit because of the estate plan that you set up to protect them and take care of them. Now, with protecting your children and yourself and your assets, you may also want to protect, again, other institutions or charities or the church. Whatever your legacy wants to look like, whatever you want that legacy to look like, your estate plan can be designed to accomplish that. If it's a financial legacy, we can create a financial plan that's designed to grow and protect you and those future generations. If you want it to leave more of a family historical record, we can help you do that. There are ways your estate plan can provide for those records. And you can create a plan to leave an emotional legacy. Again, there are things that often are overlooked if you have an attorney who is not really customizing your plan and isn't looking at all the different facets that come with leaving a legacy. One of the ways that our trust allows you to do that is by gifting specific items, so your personal property, to specific individuals. So this can be incredibly powerful. Again, when my grandma passed, I wasn't thinking about the money that could have been left. I was so excited that she had wanted to leave me some of her recipes. And so that was an emotional legacy that her estate plan was able to provide for. Now, if you are concerned about leaving a financial legacy, there are so many ways that you can do this. I've already mentioned the will and trust, but you can also have different financial means set up to pay to your beneficiaries. If you do not have a financial advisor, please let us know, because we work with an absolutely outstanding company called Lifestyle Financial Services. If you already work with them, you can definitely attest to the fact that they are also very focused on legacy building. But they're then going to take a comprehensive look at all the different ways your estate and your assets play together and will play a role. So if, again, you don't have somebody or you want a second opinion when it comes to your assets, please let us know and we would be happy to put you in touch with them. With that emotional legacy, again, this can be family history, records, different mementos, or like I mentioned, that means so much to me, those recipes. One of the cases that we had, the pivotal point actually came down to a pasta colander. And to anybody else, that seems so silly that it's a colander, you could go buy one, what's the big deal? But to that family, this was the colander that mom had cooked our favorite meals in for birthdays and Christmases. Now that she was gone, this was the memory that they had of her. It was a tangible thing that reminded them of their mother. And so again, that emotional legacy can be provided for within your estate plan and is often even more powerful than the financial legacy. So I've mentioned it multiple times, but we really do believe that your legacy matters regardless of what that looks like. Here at Koppenberger, we are incredibly family oriented, not only in our external family, but we actually have multiple staff members here who have family members that work for us as well. And so we truly do believe that it is multi-generational, that legacies, regardless of what they look like, really do matter. So if you are concerned that, does your estate plan provide for your legacy? Has it been updated to provide for the legacy you want to leave today? Or any other questions regarding your estate plan and protections, please come and talk to us. Now, if you are a new adult in your family, you should absolutely refer yourself to us. But if you know a new adult in your family, they would also be somebody to send our way, because again, those documents I talked about at the very beginning are so vitally important to have put in place. But essentially, anybody can benefit from what we do. That could be your friends, your family, your beneficiaries, yourself. If you know somebody who either is not protected or may not be protected adequately, please send them our way. And if you have not been in to see us in the last 3 to 5 years, please set up a review appointment so that we can ensure your estate plan that you took the time to set up is still protecting you to the fullest extent. So we really did cover quite a bit today. And so again, if you have any questions about your special and customized estate plan, please come and talk to us. If you have questions about your legacy or how to protect your children and grandchildren, please come and talk to us. If you have questions about finances, again, we can set you up with Lifestyle Financial Services. If you are sitting here as one of our Access members, it is really important to note that your review then would be complimentary. So if you are one of our Access members, please come and talk to us. Now, Access members get the complimentary review whether they sit through an educational event or not. But for those of you who are not what we call our Access members, because you sat through an educational event, you also can get then a complimentary consultation. So if you're on today and you want to talk with us, it would be then a complimentary consultation. So we are absolutely here to help. Our number and our website and email are on the screen. So please reach out to us if you have any questions or you need to set up an appointment. We are here to help you. We also actually now have a live chat feature on our website. So if you just have a quick question, feel free to type it into that live chat and one of our staff members will get back to you in a very timely manner. Now, if you do set up a consultation, please bring any existing estate planning documents because we want to be sure that we really understand what is currently in place to make sure, do we need to make updates or not? When you set up that consultation, we also will send you what we call our confidential data questionnaire. Please do your best to fill this out before the meeting. You may not be able to fill it out in its entirety, but it really can help us stay on track and really make sure that your situation is adequately provided for. And of course, any questions that you have for us. So please come with a list of questions. We love to answer them. There is no such thing as too many questions. So absolutely, if you have just simple questions or complex questions or a mix of all of it, come and talk to us. I'm going to leave this up on the screen for just a minute or two so that everybody can get the information. But again, if you didn't have your question answered, or if this led to more questions, please come and talk to us. Thank you so much for spending a part of your morning and Thursday with me. I really appreciate it, and I hope that you enjoyed the time. Thank you so much.